Hi, welcome to LawWiser. Today we have Megha Singh, General Counsel of ElasticRun. Being the head of legal, she has vast amount of experience when it comes to contract management and contracts. So today she's here to give us a quick bite on the impact and implications that Section 56 of the Indian Contract Act has.
Hi, Tanya.
So Megha, our first question is, what is the impact on the application of Section 56 of the Indian Contract Act?
Section 56, which talks more about doctrine of frustration or contract frustration cases. We all know that Section 56 of the Contract Act enshrines the doctrine of impossibility, which provides that a contract to do an act which, after the contract is made, becomes impossible or unlawful by any reason or because of happening of any event because of which the promiser could not perform under the contract, and that contract becomes a void contract. Under the aforesaid provisions of Section 56 of the Indian Contract Act, the contracting parties can definitely plead the impossibility of performance and consequently frustration of the contract on account of a particular event or on certain unforeseen circumstances which were not visualized or which were not known at the time of the contract drafting. There is also a relevant section in the Indian Contract Act, which is Section 32, which also invokes similar kind of a thing in the contract that more relates to the force majeure in the contract in our normal parlance. So what happens is Section 32 can definitely be visited if you have force majeure clause in your agreements. However, we have certain age-old contracts, or even in the contracts with the force majeure where there is no specific provision for pandemics or for epidemics, where we generally tend to write only act of God, strike, war, and many times there's a miss of pandemic. But this is a situation of global pandemic, and if there is a miss of the word pandemic in your clause, then we all need to definitely invoke Section 56 of the Indian Contract Act, where we need to, where the promiser or the performer under the contract needs to prove and establish that there were circumstances, there were events that had happened because of which the obligations laid onto the promiser could not be performed.
That was very helpful, Megha. If you could also share with us quickly the impact that it has on the parties and the agreements.
The government had issued strict directions imposing the country-wide lockdown. There were various phases of the lockdowns, and in these lockdowns there were restrictions on the movements across state borders, and there was closing down of various factories and businesses, and as a result of which various activities involving manufacturing, supply, delivery, traveling, construction, real estate, I mean many of the activities were just on standstill. Now there are lots of contracts in your common in your day-to-day transactions that these obligations could not be fulfilled because of non-movement of people, of vehicles. Now this has happened. Why did this situation come? This has come because of the government imposed directions of countrywide lockdown. Doctrine of frustration, which has been laid down and which has been very closely dealt in the Supreme Court judgment of Satyavrata Ghosh versus Mungiram Bangor, where it was clearly laid down that the word impossible has not been used in the section in the sense of physical or literal impossibility, but the performance of any act may not be literally impossible, but it can also be impracticable. And if it is laid impracticable, or if it can't be performed because of various situations, then definitely Section 56 can be invoked in such kind of circumstances.
Megha, if you can, in brief, tell us what changes do we see now ahead in terms of, drafting and, keeping Section 56 in mind in terms of the contracts that now would be being drafted and will come into force, keeping the entire COVID scenario and the pandemic situation in mind.
There is one very important type of an agreement, or category of an agreement, we can say, which has come into the question, which pertains to lease of properties, which leasing of properties.
Okay.
Many of our lease deeds, if you see especially the older lease deeds, which had been signed before, there is no provision of clause of a force majeure clause in that particular lease deed. Now, what do we do in these kind of situations? So, wherever there is a mention or wherever there is a provision of force majeure in a particular contract, then definitely Section 32 can be invoked. But on lack of a specific force majeure clause, we need to invoke Section 56. There is also there is also a possibility that, and there also has been a recent judgment which says that in absence of the same, the TPA Act, the Transfer of Property Act, will come into the picture, and it needs to be assessed whether the property has actually been rendered useless or unfit or not because of any factors. However, there are certain lease deeds which do not have, which predominantly do not have, section the force majeure clause in that particular scene. So in that case, what do we do? In that case, we more so it depends upon the lessee to actually come forward and establish and prove that how these external factors have actually rendered the property unfit for us. There is also a small provision which says about rendering the property unfit to be used. So in this situation where the people are not permitted to come to the office, or where there is no movement, even if the lessee is in custody of the property, there is he cannot use it, or it is still rendering it unfit because owing to the external irresistible forces. Clauses like force majeure needs to be deeply evaluated, needs to be analyzed, and needs to cover all possible external factors which are beyond control of any of the parties to the contract, should be encompassed in a watertight way in the clauses. All the clauses in the agreement, may it be indemnity, may it be termination right, may it be force majeure, or may it be obligation, should be reviewed, and actually calls for a review from the perspective of what happens if either this or any similar kind of a situation that comes, which is unforeseen or which is even unexpected as of today.
Thank you for your time, and thank you for giving us this quick bite on everything in and around Section 56 and Section 32 of Indian Contract Act. Thank you so much.
Thank you. Thank you to LawWiser, and thank you, Sania, and thank you, Sahil, for this opportunity. My pleasure.